Good evening. Captain Retired Matt Edwards here with the next installment of the Observation Post Facebook Live weekly broadcast for the 22nd of June 2023. Now, I'm going to see if I'm going to do a little bit different. I'm going to do 4 issues that I'm going to talk about, and then I'm going to wax on about something that's bugging me lately about my getting canceled from rehab back in 2013. And I go into it in detail. I've been making a bunch of notes. Anyway, number 282 from my numbered list that I've posted in the files part of my observation post group. Does the Canada Pension Plan owe a fiduciary duty to pensioners? Pensions always have a fiduciary duty. Well, the thing is that just because the Canada Pension Plan is a public, supposedly public pension, that doesn't detract from the fact that pensions are always property, and therefore the people that administer the pension are always a fiduciary. They hold the money in trust for the person who's the pensioner. Well, the Canada Pension Plan, it also has a disability component, like disability insurance. Well, in insurance contracts, when you have a contract, it's called utmost good faith. In every contract, a normal business contract and stuff like that, there's an implied duty of good faith in every contract. If you lie or deceive someone, well, that violates the contract. You had to act in good faith. You can't lie. Well, insurance contracts are utmost good faith on both parties, which means you got to be really above board. You can't, be despicable like the government is doing when it takes certain things into account to try to save itself money. Now, I've also seen cases where it said that insurance is semi-fiduciary. I think people are splitting hairs there because, well, is it fiduciary or not? I don't think you can be half a fiduciary because of the nature of a fiduciary. A fiduciary, for a bit of a review, you can be a fiduciary if you have more power than someone else, or if you have more knowledge, professionalism, like a doctor or a lawyer, or a priest, for example. And sometimes it's about money, if you're holding somebody else's money in trust, for example. But it's not always about money, you see. So anyway, I think that there's a very important question here, because fiduciary duties are about equity and fairness and justice. Now, what people seem to be thinking, and I might get into this later, but I might as well mention it now because I'm talking about it, or it just popped into my head. You see, I think the Gronowski Supreme Court of Canada 2000 case was wrong. Now, why do I think it was wrong? Because it popped into my head recently that they decided the case on legal technicalities. And pensions are supposed to be about equity and fairness. So when you look at the Canada Pension Plan, it was designed to supplement other things. Now, in the Gronowski case, the guy was said that he wasn't disabled enough, according to the Act, to qualify because he didn't have contributions during his career. That's a technicality. What they did was they denied him his disability pension based on a legal technicality, and I don't think that's fair or just. When they designed the Canada Pension Plan, it was supposed to provide help as a right. That was what the minister said in 1964. Okay, I've repeated that often enough, and I posted a picture of the Hansford where she was asked by Mr. Chatterton about that. Could you get 2 pensions? Anyway, that's about bridging, actually, instead of the help as of right. Anyway, number 283. Why did the judge in the Manuge case, a contract case, discuss the tort concept of Bradburn, 1875? In the Bradburn case, I'll do a brief recap, or next thing you know, I won't be here long enough. I'm there thinking that I might be a bit long tonight, but, if I skim over things too quickly, I'll Won't be very long at all. However, in 1875, there was a case in England where a policeman was hurt in a railway accident. He had a £30 insurance policy. The railway company argued in court that he had been compensated by his insurance policy, and therefore they didn't owe him any damages. The judge or judges said, nope, sorry, that was contract law. This is tort law. So tort law is about when someone owes you a duty of care, someone breached the duty of care, and you suffer monetary damages as a result of that breach in the duty of care owed to you by someone. Contract law is an entirely different animal. It's about consensual relations between two parties who enter into a contract. Now, that's why I said, when it popped into my head and I typed it into here, or you might have wrote down first somewhere and then I typed it in later. But why did the judge bring up in the Manuge case, which was allegedly a contract action? I don't think they should have heard it as a contract action. The McInnes Cooper's first allegations, first statement of claim, listed off a whole bunch of things, such as breach of the charter, breach of Pension Act Section 30. You know, they listed a bunch of stuff. Now, when they brought it up about being a breach of contract, well, in the contract, there was a clause saying that the Pension Act could be taken into account. So, in theory, how could you say that they breached the contract? Well, the first step in looking at a contract dispute is you look at the four corners of the deal signed by the parties to the contract. That's called the four corners rule in contract law. So, the first thing we should ask in the Dennis Manuge class action, is there a valid contract? Well, no. There was never anybody who sat down and negotiated with Manulife or the Department of National Defense a contract of insurance where they take the premiums to cover the risk of someone becoming disabled. Manulife has a contract with the Chief of Defense Staff to administer the policy for the government. But the government acted like it does all the time, and it put in place unilateral rules such as the Pension Act clawback. They also put in there the Canada Pension Plan clawback and the Canadian Forces Superannuation Act clawback. But basically, what they're trying to do is avoid paying the insurance. Now, a lot of people are going to say, that's what they always do. But no, that's not what they're supposed to do, because that's why people buy insurance. People buy insurance for peace of mind. That's the only thing you get out of insurance. You get a psychological benefit that you know that you're going to get something and you're not going to lose everything if the risk that you insure against happens. Now, in the Dennis Manuge class action, there was a lot of people called zero-sum veterans. Now, zero-sum veterans in 435 comes to mind. Around that number, say 500 veterans. They had such a large Pension Act pension clawback that they didn't get any SISIP long-term disability at all. Now, in 1978, there was a Supreme Court of Canada case called Consolidated Bathurst or Consolidated Buller versus Bathurst, Supreme Court of Canada, 1978, and they said that insurance underwriters cannot take the premium without any risk of having to pay. Now, in the case of the zero-sum veteran, because of the clawback in the contract, they avoided paying. They avoided paying the risk. So basically, the insurance was worthless. The insurance was basically breaching the veteran's peace of mind. Because instead of getting the insurance, which would have gave them peace of mind, they said, well, you know, we would have paid you, but you have the Pension Act pension, and therefore, according to Section 24A of the policy, it's listed as a clawback, and too bad, so sad. Now, if that had been a normal contract, that might have been legal. But the government decided to put certain acts, certain laws into place to protect pensions, and Pension Act Section 30 was breached. That was the law that McInnes Cooper said was broken, and they were right. Okay? You cannot take the compensation that is payable under the Pension Act and then use it indirectly to reduce another payment because you're taking it into account, and that breaches equity, fairness, justice. You can't do it. It's illegal because the government said that no one can touch this money in law or equity. Now, law is contract or statutory law, and equity is clawbacks. You see? So the government put a law in place to forbid any creditor from taking the Pension Act, either directly or indirectly. Okay, carrying on. Number 284. Does the government realize that bridging is a form of tax, so this cannot be done in disguise? What is the intent of Parliament when it made that law? The Interpretation Act, Section 12, maybe. Okay. What I'm referring to is an idea I got from a 1998 Finance Canada tax expenditures report, and they stated that clawbacks are a form of taxation. They didn't explain why. I figured it out, I think, myself, by thinking that instead of them looking at how money is being forgotten about, that's what a tax expenditure is, they were actually talking about tax spending. Like, if you have taxes, then you have to spend it. That's why you collect it. So that's a direct tax expenditure, a direct tax, cost. So when you claw back the value of something from something else, and I'll use the Pension Act and SISIP because I'm already talking about that for the Manuge class action. So the government had a payment that was going to the veteran under the Pension Act. And they had a payment going to the veteran if they didn't get the Pension Act that would have been payable out of the Consolidated Revenue Fund, out of the Service Income Support Insurance Plan. So the thing is, when they reduced the payment from SISIP long-term disability, that saved money in direct tax expenditures, and that makes it a tax. That's why clawbacks are a form of taxation. So the government has the power to tax, but they're not supposed to do it indirectly or hiding it away. So if they want to tax and they choose to tax, then they publish a law and they apply the law, and there you go. But if they say, well, we're just doing what all the other insurance companies do, and they tax someone, but they don't have the legal authority to tax under the Service Income Support Insurance Plan, it's not a taxing document. Canada has, since 1917, the Income Tax Act. We have the Goods and Services Tax. We have different acts that tax people. We have the Excise Tax Act. So you can't tax people indirectly and just pass it off. I mean, they're not doing anybody any favors when they do something dishonorable, disloyal. Because here's a kicker. According to a 1997 Hansard report, there was some committee, finance committee. They had the head of the Canadian Health and Life Insurance Industry Association, Mark somebody, and the government asked them how many people had to pay taxes on long-term disability. He said it was 25%. So 75% of long-term disability in Canada is tax-free. Now, why does the government tax disabled veterans? Under the Service Income Support Insurance Plan, they tax disabled veterans. They can be hurt in or out of service, but they tax them. And then the earnings loss benefit, which is now the income replacement benefit, is taxed as well. Now, they didn't tax the Pension Act, at least on paper. They did based on the after-tax income of a public servant, so they did tax it. They told everybody it was going to be tax-free. They put into the Income Tax Act, Section 81(1)(d), that it was a tax-exempt pension, but they based the rate on the after-tax income of a public servant. Now, if you're going to use something as a yardstick, like the public servant's salary, go ahead. But if you're paying someone compensation, it has to be free from tax. So you have to use the gross income. They use the net. You can't use the net. Not legally. It's not fair. You don't do that. If you sued someone for hurting you, you wouldn't get a payment based on your net salary. You get a payment based on your gross salary because taxes are not part of damages. Now, the second part of that, because I put 3 little points in there, I said, what about the intent of Parliament when it made this law? Well, I don't know that Parliament made these laws, okay? Until somebody proves to me that it was debated in Parliament and Parliament decided that they were going to expropriate people's property, because that's what bridging is, stealing someone's property. Pensions are property, and if you have 2 properties, they're taking one property into account with the other one, and they're reducing one property because you have another fucking one. Now, if they can show me some kind of debate in Parliament where that was debated and our elected representatives chose to do that, well, we'd have to take a different attack to show that it was bullshit. We'd have to point out that pensions are property. The Constitution gives property and civil rights exclusively to the provinces, and this is a federal law, and it's not a provincial law, so the federal government can go fuck itself. You can't exercise jurisdiction when you don't have any. See? So why this hasn't come up, I don't know. But Canada is a federation of provinces, and there's a federal government, and there's provincial governments. Now, when they decided to make the country back in 1867, they decided to divide up the powers. They gave things that were going to be cheap, like health, to the provinces. Now, you might laugh now, but at the time it was looked at as cheap. And they gave expensive things like defense to the federal government. And it only makes sense because provinces don't go to war. The country goes to war. But property and civil rights were given by agreement, by consensus, to the provinces. See? So the government, the federal government, is not supposed to interfere with our property rights because that is unlawful. It's not constitutional. The third point, the Interpretation Act, Section 12. Well, you see, when you have the Constitution, that's the supreme law of Canada, then you have the Interpretation Act, which says, well, we're going to write laws. Well, we have to know what certain words mean. So let's put in how we want to interpret all of our laws. Well, Section 12 of the Interpretation Act deems all laws of Parliament to be remedial. Now, that's an important thing because in a common law democracy, one of the main principles is that laws are supposed to fix things and not cause problems. That's what remedial means, okay? So, when they say that laws are remedial, and then you look at the Pension Act in Section 30, well, they put a law in there to prohibit any creditor from taking the pension. Now, that's a good law. That's a remedial law. That's one that fixes a problem, gets ahead of any creditor trying to take a veteran's compensation for injury in military service. It gets ahead of that and tells them to take a flying fucking leap, okay? Now, let's look at the Veterans Wellbeing Act clawbacks. The federal government authorized itself to take into account things that are pensions, which are property, under the Veterans Wellbeing Act Regulation Section 22. Now, in the original version, they listed off the Pension Act as one of the clawbacks. I'll digress here from the constitutional thing, and I'll talk about the fact that this is despicable. When the Service Income Support Insurance Plan Policy 901-102, Section 24A, took into account the Pension Act, you had the Department of National Defense Insurance taking into account a Veterans Affairs Canada payment, but when Veterans Affairs decided to do it, you had a Veterans Affairs Canada payment being taken into account under another Veterans Affairs Canada payment, and the self-interest, the bias, is palpable. It's insane. That should never have happened. The government should not be self-dealing. It's horrible. It's not, they don't even seem to realize it. Like, you can't blame it. Well, we can't help it. That's the Department of National Defense's contract. Veterans Affairs can't say that for the earnings loss benefit / income replacement benefit that it's called now. They just can't. And I was talking about the Interpretation Act. So let's say, okay, so the Interpretation Act says all laws are deemed remedial. Well, the Veterans Wellbeing Act is deemed remedial. It's supposed to fix problems. Okay, well, how does clawing back a disabled in service veterans, Canadian Forces, or Canada Pension Plan, or CISIP, how does that remedy a problem for the disabled veteran? It doesn't. It creates problems because they ignore the Constitution, they ignore the Charter, they ignore the law, they ignore the common law, they ignore the policies of the government, they ignore everything, and they simply do whatever they want to, and they hope that no one's smart enough or persistent enough, like me, to figure it out. They shouldn't be doing it. Our government is a representative democracy. We shouldn't have the government doing things that are bad for the country. None of this stuff helps recruitment and retention. None of this stuff helps the rule of law. All this stuff does is create a huge liability for the future when they get cut. Okay. Number 285, review the Financial Administration Act, Section 68, to see if it might apply to clawbacks. Well, Section 67 says you can't assign a crown debt to someone. The Section 68, and I didn't look it up, I was a bit lazy, but it says that nobody can claw back a public servant's pay. Now, the government keeps claiming that the Canadian Forces pension is income, the Service Income Support Insurance Plan is income, the income replacement benefit is income. Well, if they are, then the Financial Administration Act says that nobody can touch them. And I'll give you an example from the divorce field of law. I've been reviewing and trying to help, reviewing cases and trying to help veterans that have been going through divorce. And I've seen the Service Income Support Insurance Plan being taken into account as income when it's not. It's a non-indemnity and contributory insurance payable in respect of the premiums that the Canadian Forces member paid when they were healthy, based on the risk of disability, and you might never get it if you don't become disabled. It's not income. Income has to be certain, okay? No one can call something that you're not certain about income. Like, you have to know you're going to get the money. If you put time in with an employer, you serve an employer, you have a contract, you know you're going to get paid, all else being equal, because that's how income works. You gave them time and they had to compensate you for your time. Okay? But if you come across money that's sitting on the road, you find it. That's a windfall. That's not income. You buy a lottery ticket and you win. That's gambling. It's not income. It's not certain. See? That's one of the key parts of income. It has to be relatively certain. Now, anyway, I'll call it quits on these 4 points. And I'll get up the file about my rehabilitation, because that's where I've been making a lot of notes. Now, here's the broad strokes of where I'm going with this. I don't know what I'll do. I might call the Member of Parliament again. I might go protest. I don't know. I might check with the Office of the Veterans Ombudsman. I might just get a lawyer. But what happened is that when I got medically released on the 19th of January 2012, I had a transition interview with Veterans Affairs Canada that day. So I have a copy of the consent form I signed, for example. Now, I thought I was going to get the Service Income Support Insurance Plan automatically on medical release. That's the way it's supposed to be since 1999. I didn't get it right away, and I was fighting with them for so long to get it that I went down to Veterans Affairs to put the ball in their court, and I said, listen, guys, what are you going to do for me? These bastards at National Defense is not paying me the insurance I thought I'd get automatically. So here I am. What are you going to do? So they had me fill out a form for the rehabilitation program, and they had me fill out an application for the earnings loss benefit program. Now, I then got approved, and they said that 5 of my medical conditions were caused by my service, and they gave me a rehabilitation record of decision dated the 13th of November 2012. So they said that my depression, anxiety, obsessive compulsive personality disorder, anyway, that's 3 of the 5. So the earnings loss benefit application, however, held up the payment of my earnings loss benefit, because normally it's supposed to go hand in hand. Okay, you get approved for rehabilitation, you get then paid the earnings loss benefit. According to the Canada Gazette in 2006, for the first 24 months when you're on rehabilitation, you get the earnings loss benefit to assist you while you're too disabled to work. Okay, so it's supposed to give you a support while you're on rehab. But after 24 months, it then turns into compensation for your lost income, they said. Never mind that there's no such thing. That's what they claim it is. So here it is. They asked questions that they didn't have any right to. Okay, so they put on the application, they said, well, do you get any long-term disability? That put me on the spot. Okay, let me back up the truck a bit first. At the time, I didn't know about it. However, during all of my research over the years, I discovered a audit by the Privacy Commissioner on Veterans Affairs Canada. It had something to do with leaks and disclosures, and I think Sean Brea was in the middle of all of it. So they said that 90 or 95% of the Veterans Affairs employees had their privileges, their privacy privileges reduced, and 500 Veterans Affairs Canada employees had them stripped altogether. Now, that's the broad strokes about the audit, but there was one particular point that also applies to me. I just recalled the other day. I feel that both the earnings loss benefit and the rehabilitation applications at the same time. Now, in that report, they said Veterans Affairs Canada does a boo-boo, a tiny mistake. Until the person's accepted into a rehabilitation program, there's no need for the information on the application for the earnings loss benefit. So if you take both of them and at the same time, and then you get denied rehabilitation, then you over-collected personal information because you accepted the application that you included both at the same time. Now, yeah, it sounds a bit stupid, but I can see the point. So they did that to me. So I filled out both at the same time. I got accepted into the rehabilitation program, but the ELB application went to a different group of people, and they didn't like my answers. Like they said, do you get long-term disability? I said, yes, I get Sun Life from my civilian job, but it's non-indemnity and contributory, so it's none of your business. They said, do you get any pensions? I said, yeah, I used to work for CRA. I get a Public Service Superannuation Act pension. But again, it's non-indemnity and contributory. It's none of your fucking business. Now, they're not used to that shit. So I was in the program, and I never got the earnings loss benefit because they looked at it as I wasn't playing ball. I'm sure that's what they thought. I was caught in a conundrum. They want to ask me questions about things that they shouldn't be asking. For example, and I meant to say this earlier, talking about the Manuge case and stuff, the Pension Act does not claw back the Canada Pension Plan disability. It doesn't claw back the Canadian Forces Superannuation Act disability. It doesn't claw back the Public Service Superannuation Act because that's how compensation for injury works. It doesn't take your own property into account. See? So the earnings loss benefit, because of those Veterans Wellbeing Act regulations that I was telling you earlier, it violates all these rules. Well, they wanted to know personal information about me, my personal information, my financial information, and I knew they didn't have the right to do it, so I didn't want to be told I was a liar, so I put down the reason why I wasn't giving it to them. Of course, they don't seem to understand it. Now, a little bit of personal facts. At the time, I was pretty sick. I had just got out of the military, and I developed diabetes. Didn't know it was diabetes. I thought it was depression. When my eyes got blurry, I realized it wasn't depression, because depression will cause your eyes to be blurry. So I went to the doctor and found out that I had diabetes, type 2 diabetes. Now, that meant my health was horrible. I was sick as a dog. I still dragged myself to go on a trip we had planned to Germany. My wife and I went to Germany from the 10th of April. I looked these up the other day to make sure I had my facts straight. So I had a trip to Germany for 2 weeks, and my wife and I went there. We took a side trip to Italy and Switzerland and Austria and stuff, and saw a bit of Europe, but I was still pretty goddamn sick. Now, when I got back, I don't know if I ever got in contact with either CISIP or them. Now, CISIP, in the meantime, I was fighting with them to get my insurance, and I finally got it on the 11th of March, 2013. They finally approved me. So they approved me for the CISIP, and they paid me retroactive. Now, then, back says in a letter dated June 7th or something like that, oh, we've been trying to call you on this date and this date, and we sent you letters on this date and that date, and we couldn't get in touch with you. Now, it was a 5-week period that only occurred to me recently. So they said they couldn't contact me over a 5-week period, despite the fact that I was in the rehab program since November of 2012, and all of a sudden they picked out this little tiny window, and they tried to get a hold of me. Now, when that happened, not long after I got kicked off, and I'm pretty sure I went to visit, I looked it up on my Facebook and I couldn't find it where I made a note of it. I wasn't posting much back then. But I spoke to the case manager, Charlene Ferdinand. And I said, Charlene, you know, when I used to work for CRA, if I couldn't get a hold of a taxpayer who owed money to the government, I would send the file up to a higher level agent, and they would do a field call to go knock on the door and see if they can get in contact with that person to collect the taxes. Now listen, you said you were trying to get a hold of me and you couldn't get a hold of me. Could you, based on your job description, get into a car, start it up, go visit me, knock on the door, and see if I was still alive? And then I would have answered the door, my wife would have answered the door, and then I would have still been in contact with you. Oh, yes, I could have done that. See, that makes it their fault, not my fault, that I didn't get in touch with them over that short time period. Now, the gist of this letter that I'm going to do, or whatever, when I'm doing all these notes, is that it isn't very fair. I had to be hurt in service in order to get into rehabilitation. After I got into rehabilitation, there are many case managers that claim they're overworked, that they have too many disabled veterans that they have to look after. So I look at this as possibly her lightening her workload. So they had a chance to get rid of me. And plus, I'm probably always looked at as a person who's a troublemaker. So the gist of all this, the nuts and bolts of it all, they're asking questions they shouldn't be asking, breaching your privacy. Now, that's a law. The Privacy Act says that you are not allowed to collect information until you need it. That's what the Privacy Commission's audit in 2012 was about. Now, the dates are important. I got kicked off of rehab in August of 2013. The privacy audit was October 2012. So they ought to have known not to include both ELB and rehab applications in the same envelope at the same time, because it breached the law. It breaches the Privacy Act. But the ridiculousness of this, it's not just in my case, it's in all cases. Because when the Privacy Commission made the report, Veterans Affairs' response was, oh, we'll let the veteran know that they have the option not to fill it out at this time, but it'll delay things. So we're going to ask them to fill it out anyway. You're not supposed to ignore the law. You're the government. You're supposed to follow the law. If it says that you had to collect the information only when you need it, then collect the information only when you need it. However, I digress, because there is no such thing as rehabilitation, okay? Now, people might look at me strange because we know how the government does it. The actual benefit is the income replacement benefit or the earnings loss benefit. Rehabilitation is a condition of benefits. So they want to keep an eye on disabled people. So they put it into a system where they have they have you under their thumb all the time. And here's another thing that occurred to me during all of my research. Case management, rehabilitation. You might be in rehabilitation, but you don't need a case manager unless you have a complex case. All of the veterans in the rehabilitation program aren't supposed to have a case manager, although they think that's a bad thing if they don't have one. But it's only supposed to be for complex cases. So was I a complex case? Did I need a case manager? Did I need a case plan? I don't know. I never developed one because I never got in touch with them before they kicked me off the program. Now, when I'm there doing all this, talking about all this stuff, someone might say, well, it's 10 years ago or 11 years ago. Well, yeah, it was, but it still wasn't right. It still wasn't fair. And they ought to be using not insurance principles. They shouldn't have an insurance culture at Veterans Affairs, even though, ironically enough, they pay insurance. They have an insurance program. The Pension Act was insurance. It was an indemnity insurance, and you got compensated for your injury. And the rate of compensation was based on the after-tax income of a public servant because you couldn't work in the general labor market. So if they said you were 70% disabled or 90% disabled, then they looked at the 100% rate and they gave you 70% of it. And that's the way they designed the program. Now they took a different design model under the earnings loss benefit. They copied the service income support insurance plan. They said they were going to make mirrors of each other. Dara Mogan, one of the deputy ministers at Veterans Affairs in one of the Senate Committee on National Defense and Veterans Affairs, they were talking about that, and they said, for example, we have the 120-day application period, which we have under the earnings loss benefit, which was also in the service income support insurance plan, so we copied that, so we'd have things pretty well the same. Same thing goes for the clawback. Same thing goes for the 75% rate. Same thing goes for the reserve force SISIP that became Reserve Force Earnings Loss Benefit. SISIP pays a disabled veteran who is a reservist 75% of $2,000. That's a deemed flat rate amount for everybody, whether you're a general or a private. VAC copied that. However, around 2011, they brought in Bill C-55 to change it because they realized that wasn't fair. They had a rate that was in place since 1991 when the reservists were added to the SISIP policy. And it has never been indexed for inflation. That was back in 2011, I mean. So in 2011, they indexed it for inflation and brought it up to 75% of $2,700, which comes at $2,025. That was the rate I was approved for. But they haven't increased it since. So that was 12 years ago. So they fixed it once, and they didn't fix it again. Now, Veterans Affairs and the Department of National Defense decided to part ways a bit. Up until then, they were pretty well in lockstep. But it took the earnings loss benefit change for the disabled reservists changed right away, but it took about 10 or 11 months for the government to strong arm SISIP, National Defense, to change its rate. But the thing is, and then in 2015, the same thing happened. In 2015, they said, it's not really fair. It's like paying men and women different salaries to do the same job. Well, if a person's a reservist and they get disabled, they get this rate. And if a person's a regular force person, they become disabled in service, they get that rate. And they're not the same. So that isn't fair. So they've repealed Section 19 4B of the Veterans Wellbeing Act regulations, which was the offending clause, and that meant they had to treat all disabled veterans the same, and you got 75% of your rank-based pay. They didn't do that for me. I was in the Service Income Support Insurance Plan. I didn't get it. I wasn't in the Veterans Affairs system, which brings me back to the cancellation thing. I suffered monetary damages because I wasn't in the system. if I had been left in the system instead of saying you didn't contact us in this 5-week period, so therefore we're kicking you to the curb, well, even if they weren't paying me, I would have been in the system. And when the government announced a fix for the reservists in 2015, I would have got it. Without question, I would have got it. Just like any other person in the system when the change happened. But because I was on the outside looking in, I didn't get it. Now, that happened again in October 2016 when they changed the rate for earnings loss benefit to 90%. I wasn't in the system, so I didn't get the increase in the payment. So these are actual monetary damages that if I go to a lawyer and I convince them to take it, I'd probably have to give up 30% of it, but I could stop doing these videos and I could stop trying to argue with the Member of Parliament. I could stop talking to the Office of the Veterans Ombudsman and the Royal Canadian Legion and everybody. But I don't like giving up 30%. Why should I even have to try to convince a lawyer when the government is doing this and they shouldn't be doing it? Okay? There was a case in 2003, Supreme Court of Canada case, injured worker in Nova Scotia, Martin, his name was. It was said to be discriminatory against the charter, even though he would have had a 0% compensation payment. He had chronic pain, and they had different rules for chronic pain than a regular physical injury. Now, the Supreme Court rightly said that's not fair. You can't treat this injury different than that injury. And they said that being part of this organization is a benefit. Well, that's the problem. 2003, that was 10 years before they kicked me off of the rehab. They should be aware of common law decisions. They should know what they can and cannot do. But they might, I don't know. Maybe they know that they're not supposed to do all this stuff, and they do it anyway. Now, I've had enough talking about rehab time. Let me tell you about one other project I'm working on today. I've been working about how the family has been affected by all this shit. A lot of people look at this, and they think, well, you know, that's just the way it works. Well, I'll get back to a point about earlier when I was talking about equity, okay, when pensions are about equity. Well, compensation for injury is about equity as well. It's not about legal laws, it's about fairness. If you injure someone, you have to pay them back for the injury. It's your debt. See? So instead of looking at my rehab program and saying this person didn't contact me, so therefore I'm going to kick him off. Well, the law actually says may. I punched it in here. Let me look it up. Okay. Section 17 of the Veterans Wellbeing Act, which, you know, at the time was called the Canadian Forces Members and Veterans Re-Establishment Act back in 2013. In the letter that the lady sent me, the case manager, she said it's under the regulation section such and such, but the regulation refers back to the Act in Section 17. Now, it says in Section 17, the minister may, not shall, cancel a rehabilitation or a vocational assistance program in prescribed circumstances. That's pretty general, isn't it? They don't spell it out. Now what they do is they spell it out in the regulations. So one of the things that they say, and unfortunately I didn't type it, I put in a picture here. It says again, for the purposes of Section 17 of the Act, the minister, again, I put a red box around it, may, because may is different than shall. Shall is mandatory, may is discretionary. May cancel a person's vocational rehabilitation plan or vocational assistance plan if the person does not participate to the extent required to meet the goals of the plan. Now, here's the thing. I didn't have a plan. So how could they say that I wasn't participating up to the goals of the plan when there wasn't a fucking plan? First of all, they needed to develop a plan with me. But that's also a very arbitrary and subjective point. I have a veteran I was trying to help. She was in a motorcycle accident. She hurt her knee. She was in rehabilitation. It was medical rehabilitation, by the way, not vocational or psychosocial, because there are 3 types of rehabilitation. When she hurt her knee, she got kicked off of rehabilitation because she couldn't participate in the medical rehabilitation at Veterans Affairs, when any reasonable person would have brought that extra injury into the plan and amended it instead of kicking her off. Don't you agree? She ended up having to go to court about it. She won. They got into a legal technicality. They sent her a letter, and they accidentally said a year later than the year they meant. So they said, we're going to cancel your rehabilitation in June of 2017, when they meant June of 2016. Well, I said, you got them right there. I said, they can't change their minds. They put it in writing. They told you in a year's time, you're going to have your rehabilitation and your earnings loss benefit canceled. Now, of course, they ignored the fact that the common law would stop them, and they cut off her earnings loss benefit and kicked her to rehab. So she hired a lawyer who used to be an admiral in the Royal Canadian Navy, Larry Murphy. I spoke to him a couple of times. He charged her $1,500 to represent her, and they won. The government caved in because they didn't have a case, okay? And they put her back in the program. However, they still screwed her over because they didn't put her back into the date where they kicked her off. They only put her in as of now. That pissed me off so much. I called Minister of Veterans Affairs at the time, Kent Hare. I called his office and I left a message. I said, you tell the minister that unless he wants to go to jail for ignoring a court order, pay this person their compensation under the Veterans Wellbeing Act, because she went to court, won, and you guys lost. You can't just make a payment going forward, because why did she take it to court in the first place? She took it to court to fix, to remedy the problem. How come everything seems so clear to me, but it can't seem clear to these idiots? They're not looking at the equity, the fairness, the justice. All they're looking at is technicalities and trying to find out ways to kick people off or exclude them or reduce payments or however they can do. And it harms us. I saw, and I intend to do something up on this too. I have so many projects in my head that's unreal. There are two quotes that are coming to mind. The 8th Senate Committee on National Defense and Veterans Affairs, 8th Scandal Report, talked about, at the very preamble, at the very beginning, it said that most disabled veterans are too upset and they can't even look after their own selves alone, try to promote themselves. Now, that was a very good point. They're right. The other one was a fellow I've spoken to a lot. He's been trained as a lawyer with the Office of the Veterans Ombudsman. His name is Dwayne Shippers. And he was doing a report to somebody, and basically he said that, people are worn out. It's the tip of the iceberg, how many people are dissatisfied with Veterans Affairs. They're worn out by all the paperwork. But the paperwork is on purpose to wear us out. In the 1990s, there was a book, an expose from the U.S. insurance industry, and the upshot of it all was they had a saying in that industry: delay and deny, confuse and refuse. Now, if you're a disabled person, alone a disabled veteran, and you get caught facing someone that's intending to do you wrong, because remember, the intent of insurance is supposed to pay the insurance when the risk happens. But these people are so despicable, so disgusting, that all they want to do is make money. And if they can confuse and refuse, or delay and deny a payment to someone, they look at it as a good thing. It increases their stock price, maybe. Maybe it gives them a bigger salary. But that's not why insurance is sold. I mean, I only know the theory. I've never been an insurance salesman. But if they did what they're doing and everybody knew they're doing, no one would buy it. Right? So if nobody buys it, that means that there'll be no one selling it. There'll be nobody working at the companies, nobody adjusting it, nobody doing the administration. It'll be a mess. It would harm our economy. What they need to do is do it right and pay the insurance when you're supposed to get it. Because otherwise, it's harmful to society. I'll make one more point. It's about the family thing again. Well, if they take into account my Canada pension plan with my public service pension and my reserve force pension, which they did, they are expropriating property from me, but it's also my family's money. Okay? It's going to affect my family because I have less money because they took money into account and reduced the payment. Now, people often like to transfer money to their descendants, inheritances and stuff. But our property has been affected so that we have less money to transfer. It's insane. And they're doing it all without the right to expropriate without compensation. Because all of this is very similar to the Otterson Supreme Court of Canada 2003 case, in which interest, which they said was property, was expropriated without compensation by the federal government. And they said, well, you know, when the government, it's not very nice to do, but when the government that's elected decides to expropriate someone's property without compensation and it writes clear law to that effect, there's little that we can do about it as the court. Now, go fuck yourself. Go fuck yourself. Okay? In the Department of Veterans Affairs Act, they didn't say we're going to expropriate the veterans' property. They said we're not going to pay any interest. That's not a clear law saying that we as the elected government, who was elected by the members of Canada, the voters, we are voluntarily choosing to expropriate the property of disabled and service World War II veterans, because that's who they were, who could not look after their own affairs, and we were administering their pension in trust, so we were a fiduciary, and we have decided that we're not going to pay them interest, we're going to screw them over. They just said we're not going to pay interest in that law. So how did the Supreme Court decide that that was a clear law, that the government was going to expropriate the property of the veteran without any compensation? They interpreted it, but they didn't interpret it in accordance with Section 12 of the Interpretation Act. It's disgusting, okay? It's a very short decision, and it probably was the court just giving the government a win because of the cost, $1.07 billion. So the veterans from 1945 till 1989 were supposed to get $1.07 billion, but the government decided to screw them over, and the Supreme Court let them get away with it. Now, here's the kicker. I've talked about this before. If I told you about it before, and you're saying why you're repeating yourself. During the case, the government said, the judge said, there's a memo from Veterans Affairs saying that here are the options to fix this problem. Number one, do nothing. Now, hang on. You're a judge. You're supposed to serve the community. You should have said that the government is not supposed to cover up their mistakes. Why didn't they say that? Number two, pay each, defend each claim, or, as it comes up. And then 3, 4, and 5, whatever. The government is supposed to be above reproach, okay? They put into the criminal code a section about good government so it would remain above reproach. If you do something that's not above reproach, you can go to jail if you're a public officer. As an example, because I've done a lot of research on this too, a police officer in Quebec covered up for his buddy in a drunk driving case. Probably happens all the time. I was shocked to see that the cop got charged and convicted with breach of trust by a public officer because he covered up for his buddy and he should have done his duty and charged him. I was surprised as hell that the case made it to court so I could read it. But the thing is, when that person at Veterans Affairs, and I presume it was fairly high up, that person was a public officer. They had a duty to the public, and the 5 elements of the crime, by the way, are number 1, the person is a public officer, the person here. Number 2, this and 3. Number 4 is what is the duty of the public officer, and then number 5, how did that act differ from the expected duty of a normal public officer. So if you have a public officer, a Veterans Affairs person, it could be a deputy minister or somebody, had to be high up as far as I'm concerned. And they knew about this problem with the veterans not getting their interest. They shouldn't have said, do nothing. To me, that's breach of trust by a public officer. They should have been charged and convicted, as far as I'm concerned. Maybe if they had, maybe we wouldn't have all this other crap that happens. You know, I mean, even the Manuge case, and I'm going to shut up in a minute. I know it's hard to stop. I'm getting dried out here too. They knew about the problem in the Manuge case a long time ago. But they kept saying, you know, so what? This is what everybody does. My member of parliament keeps telling me that. My member of parliament staffer keeps telling me that. Her name is Ruth. And I had a fairly contentious meeting with them last week, and I spoke to her about 2 hours, and it wasn't very conducive. And I'm getting tired of the gaslighting, you see. If I say, well, I'm having my Canada pension plan, disability clawback, my public service pension, my reserve force pension plan, my Sun life insurance, and SISA at the time. So I had 4 clawbacks of the Canada pension plan. I don't want to hear her say, well, that's what always happens. Because that's what she said. Now, if it only happens once, maybe that's what she meant. See? But I have 2 insurances, and I had 2 pensions. Now I only have 1 because SISA cut me out. Okay? But the thing is, these people ought to be coordinated with each other. If it was legal, if clawbacks were legal, they should make sure that no one goes in the hole. That's equity. That's fairness. But equity in law gets mixed up because you'd have to go back to the Canadian Forces Superannuation Act, Section 83, that prohibits it. Canada Pension Plan Act, Section 65(1), which prohibits it. Financial Administration Act, Section 67, which prohibits it. Public policy prohibits it. Well, I know what I was going to mention about the family thing, that point I was going to do. One of the things that people that are disabled have is a shorter life. So I have to put into my letter that I've done up that my family is going to be deprived of my time. Now, maybe that's a good thing. But you won't have, because statistics are women live longer than men. My wife is the same age as me. So if, say, for example, I died 5 years quicker, then that'll be 5 years that I wouldn't be with my family. And these payments they have set up are set up that you had to be getting those. You had to be alive. See? So, I mean, some of them have a survivor pension, but SISIP doesn't. The income replacement benefit might. I don't get it, so I'm not up on that anymore. I have to start getting caught up again with things. There might have been new changes that I haven't become aware of yet. To be honest, I don't really want to find that they're making things worse. I mean, the date for the end of SISIP is coming up, the 20th of July or 2025. They said in 2015 that they're going to get rid of SISIP by 2025. I wonder if anybody told SISIP. Listen, been talking long enough. Don't know if this kind of chat does much good because, I mean, I was kind of rambling. I don't have a script. I'm sure I could have thought of things that I will think of later that were really important, but I'm getting dried out. I'm sure people are getting tired of watching. Hopefully, this will all be worth it one of these days. Because, I mean, basically, I've been crapping all over the government for my privacy, and I'm here blabbing all about it. But I'm deliberately doing it because I want to expose these bastards for what they're doing. And, well, if you got to crack an egg and breach my privacy and I got to tell you about this and that, well, hopefully it'll work out in the long run. Anyway, thanks for watching. I'll see you next week.